Kathy.
It seems to me that one of the very sensational and extreme violations of the privacy was in the Bush administration when the CIA agent Valerie Plame was outed. Was there anything? What was the follow-up to that legally?
Oh, I don't know the answer to that question. I'm sorry. Somebody else in the room know the answer to that? Adam in the back.
Nobody went to jail except for a reporter. Scooter Libby, Vice President Dick Cheney's chief of staff, was prosecuted, but not for the underlying offense, although he did disclose Plame's identity, but for perjury. His sentence was commuted by President Bush.
Thanks, Adam.
Thank you very much. Sir?
I'm not sure of the case, but it was fairly recently in Texas that a Mexican national was executed, I believe, who had been denied access to the Mexican consul. And I know that you didn't particularly mention treaties as the law of the land, but I wondered if you would comment on that.
Who are you directing your question to?
Sure. I mean, in general, treaties, if you read that Article 6, treaties are below the Constitution but above federal laws. So they certainly wouldn't trump the Constitution. So even if, so the way it works, treaties is the Senate has to approve a treaty, and even if it's incorporated, right, so it becomes part of the law, the Constitution would still trump. So if there's something in the treaty that was inconsistent with the Constitution, it would trump. But that wouldn't mean that if the treaty added something, right, then that treaty would be, and it was, assented to, incorporated into law, it would have to be followed. So I'm not sure about the specifics of your case because I'm not.
My understanding was that Texas had executed this Mexican citizen who, during his trial or pretrial detention, had been denied access to the Mexican consul.
It's a case called Medellin. And there are a number of legal issues involved. First of all, what was the nature of the treaty rights? To what extent are states obligated to respect those rights? And then in criminal law, and this is surprising to people, oftentimes rights go by the wayside, but that doesn't lead to the conclusion that the person should be set free or receive another trial or be free from execution. There are doctrines known as harmless error doctrines, which recognize that trials are not perfect and try to evaluate whether what happened in a particular case was so crucial that a remedy will be fashioned.
This is Justice Duggan or Professor Silvey. Could you address the status of privacy rights in schools now? This is the TLO line of cases as they go forward, and we have drug dogs going up and down the rows of students and things like that.
You want to go?
I think the court has cut back on that some, yeah. But with respect to drug testing. But frankly, I don't know of a lot of developments in that area. Do you?
Well, I know the trends, which are that school children have less and less privacy rights, and that it's been on the waning end of privacy, and because the countervailing interest has often been safety, and guns and drugs, and also the increased of the digital connectiveness in the school has made people more anxious about safety, bullying, and stuff like that. And so again, this issue of privacy morphs with the anxieties that counteract against it. So the trend is definitely that teachers, I should say, teachers as well as students have significantly less speech rights, and it's mostly the speech rights. So it's decisional autonomy and search autonomy in the schools.
School districts in New Hampshire have, on occasion, had a widespread emptying of the school where the kids have to deposit their backpacks.
Yeah.
And then they have the drug dogs go past the backpacks. We all know why.
Right.
As a parent, I guess it makes sense.
Yeah.
But as an honor student,
Yeah.
I can see an honor student or any student being offended by having a dog sight on there.
My guess is it goes like the prisons. That there's a larger policy at play.
In more ways than one.
In more ways than one. Right, it's very depressing when those analogies are drawn, but that's, the lawyers reason by analogy, and that's the way it would happen, I think.
On the other hand, they did have the two cases that Professor Selby argued a couple of weeks ago about the dog sniffs, and one was at the home and one was someplace else.
Yeah.
And I agree that the one at the home is going to be unconstitutional. But the argument, at least what I read in the paper, was that Justice Scalia was all over the defense for not taking a stronger position of protecting against these sniffs. It's hard to distinguish the dog sniff from the heat sensor.
Yeah.
And that's the quandary of the court. And pretty soon there'll be dog sniffs without dogs.
And just quickly, one of the things that sometimes lawyers try to guess about how this is going to go is how much can the judge imagine themselves in the position of the person being searched. And so the prison one, they had very little empathy with the idea of this being a problem for me. With the GPS case, like they could, and actually was asked during oral argument, if GPS was put on my car, could you follow me? Could that work? And that sort of blew the whole argument out of the water. And so I think one of the questions about schools is they're imagining their children or their children's children, for example, in that situation.
You may find the New Jersey.
I'm going to call on, excuse me, sir, I'm going to call on some people who haven't had a chance to talk yet. So, right here in the middle, sir.
If our goal in this whole situation is constitutional literacy and education, it seems to me that an area that we're not, I don't know if we can affect it, is TV. For example, Penelope on CSI and Proby on NCIS seems to be violating people's privacy rights all over the place. And the question, I mean, obviously it's a story, but I mean, I never had to teach kids about the Miranda warning because they knew it from TV.
Yeah.
But, I mean, are there any senses where, for example, bar associations or whatever try to at least say to producers, you know, maybe you ought to try to do this, you know, raise issues in there? I don't know, but it seems to me that's where we get our information.
I'll tell you this, when I was a law professor, the biggest enemy of a law professor was the cop shows on TV. They thought that was actually what happened, and it isn't.
Yeah, at the same time, though, so John mentioned, the only reason I mentioned, I just edited a book about law and television. And so there's both hugely mischaracterized representations of certain rights or non-rights, but also there's a lot of accurate or embellished stuff, too. So students come to high school or come to college or law school with polarized views of what they have. I don't know whether the television shows can be incentivized to be more accurate, but I will say law schools run street law programs where, for example, at Suffolk, we go out and we teach high school students about search and about privacy, for example, and the students love it. It's a fabulous civic engagement.
This is a general institutional structural question, which either Sonny or Judge Duggan probably handle, because Judge Duggan's talking about decisions that he participated in on the New Hampshire Supreme Court, decided under New Hampshire law. And just for clarification, could you just address the differences in deciding cases under state constitution versus federal constitution, just for the edification of the audience, I think. And certainly, I think for a while there was kind of a sense that the New Hampshire Constitution, with much of the same language, was being interpreted in some ways more strictly than the federal Constitution. So just
that's right. And so that the law is that we have to follow the federal Constitution as a state appellate court. On the other hand, we can set a higher standard under the state constitution that's more protective of the constitutional rights of New Hampshire citizens. And there are a couple of areas where the court has done that. One is, for example, in the area of automobile searches. Under the federal constitution, when the police search a car, all they need is a car and probable cause. Under the New Hampshire Constitution, not only do they have to have probable cause in a car, they have to have a warrant. Mm. And then there's another case that the United States Supreme Court decided that allowed the police to search through people's garbage. And we decided a case maybe 8-10 years ago now that said that that is a search. You have a reasonable expectation of privacy when the garbage is sitting outside your house in a barrel, and that the police need a search warrant to do that. So you're right, that's an important area of jurisprudence that is true in New Hampshire and many other states. Mm.
Yeah, I mean, I'll just add to that. That's exactly right. That, this Constitution, the U.S. Constitution, sets the floor, but allows state constitutions or interpretations on to set the ceiling. Now, one thing that's interesting, and you think, well, why are state judges bound by the United States Constitution? I mean, I didn't mention anything about state judges. In fact, Article 6 also has an oath or affirmation clause that says all federal officials and state officials, including judges, state judges, have to take an oath to follow the Constitution, right? So that's right, when judge says, they have to follow the United States Constitution, that's because it's also written in there. There's an oath that they have to take.
One of the questions we ask, though, is what does it mean to give more rights than the U.S. Constitution grants? When the Constitution is a floor and you amend your Constitution, the state Constitution, to say that marriage is only between a man and a woman, for example, is that a more or less than that? That's one of the interesting and important debates that we have about this, about dual sovereignty.
Sir?
Yep. I'm just wondering if there's a progressive sense in the ignorance or the law of a reasonable expectation of privacy when you go from letters to wire telephones to the wireless medium it's increasingly people are using now. It's almost ubiquitous. And to say, well, anybody can intercept these things, do you have a reasonable expectation of privacy, and is that then impacting on the court's perception of what's private?
So,
and without knowing that they're really giving that up.
right. So when you go on and you download a document, or you download a piece of software, or you buy something, you do a click-through agreement. You're clicking that box just so you can push the button that says buy or whatever. That click-through agreement is actually, no one reads them, but it's actually a waiver, well, many, even lawyers don't read them, a waiver of your rights, of many rights. And so what I hear argued a lot is that waiving those rights is knowing, and that it diminishes what you expect your rights will be, one right being privacy. And so being questioned now is whether those click-wrap agreements, they're called, whether they should be enforceable, actually, because they do such detriment, in fact. And so I think that's a very good, when it's so ubiquitous and it's the way we have to live in our lives, whether we have to agree to that kind of waiver. Yeah.
But you're right about the progression. I mean, the law has been clear for years that the government can't open your snail mail.
Right.
They can't open your snail mail, period, paragraph, without a search warrant. So, but your email,
because it goes through Verizon, they can. They just ask Verizon for it because you've clicked that agreement.
And people are not aware of the compromises that they're making as they go along.
They are not aware.
And for a long time, people thought their bank accounts were secret.
You're right. Your bank accounts aren't. You actually signed that, too, when you signed up for a bank account.
It's not.
So kind of building on that, I was just wondering how important...
Just a little louder if you can.
Sorry. I was just kind of building on that, how important is that kind of seeing how social media and all that stuff is kind of taking over and everything's kind of going into the cloud where all this information is just up in the air and people just store everything. How important is that in legislation to kind of see more restrictions, not necessarily restrictions, but kind of regulating how that information is put out and how much can be taken?
Storing information.
The cloud. So if we're talking about civic advocacy, the cloud, another analogy.
I don't do the cloud.
Does anyone know? Can you explain what the cloud is?
So when you upload, so if anyone has Dropbox, or you get documents from a central server somewhere, and you can store information not on your server, but in what they call the cloud. But it's actually a physical space somewhere else, I should say. It's not actually in the clouds. But it's physical. It is spatial. Someone has to search that server. But in terms of civic advocacy, one of the things that could happen is that people could refuse to sign those agreements, which is not likely, obviously. But you could amend the agreements when you sign them. So there are, they're considered radical revolutionaries, but when you have a form agreement like that, you could edit it. You could say, I actually protest this particular part. Or state laws could be passed to say those click-wrap agreements are unconscionable. It could be just a state law contract doctrine that says we do not recognize the enforceability of that, and the more states that engage in that kind of decision-making, refusing to acknowledge, that's a movement, that's a state law movement that could be evidence of what kind of privacy people generally expect with regard to that data.
For like a search engine like Google, because I know that when you type anything in, they just automatically plug you in for those words, and they can kind of extrapolate from those things you're searching all kinds of information. And I know they sell like advertisements and stuff like that.
Yeah. So you can. One of the things that is used as evidence of your expectation of privacy is how many people mess with the privacy settings on those kind of things, for example. So on Facebook is a perfect example. If you don't change your privacy settings, they're defaulted to the most open. But if the more and more people that actually change those privacy settings, more and more evidence of desire for privacy and what our expectations, even in a public forum like that, are. Google doesn't have the option of changing those privacy settings, but they have very strict privacy laws internally governed.
Last month, Justice Souter shared with us his belief that when you think of the Constitution, it's helpful to think of two constitutions, a structural constitution and a liberty constitution. I'm curious if the panel sees the same kind of dichotomy, and a question for Professor Beatty is, if you agree that there's such a dichotomy, does it affect your paradigm of superiority differently on the two pieces?
That's a good question. I mean, my initial response is I'm not sure I'd necessarily see it as two separate constitutions, because if you look at what is considered the liberty part of the Constitution, the Bill of Rights, were meant as structural provisions, right? I mean, they were meant to limit the power of Congress. They didn't apply to states, right? First Amendment says Congress shall make no law, right? So on one hand, I see what are considered liberty issues, right, which you would consider. So, for example, violations of the right to privacy, violations of equal protection. I actually view as structural provisions. I think we can conceptualize them as structural provisions. So I wouldn't necessarily think that that would then be consistent with the idea they're structural in the sense that they say, look, there are certain powers that the federal government and the state governments have that they're limited, their powers are limited under the Constitution. And so we should really sort of view. Actually, this is, academics always make shameless plugs on their work. So I'm writing a book actually on equality, equality under the law or reappraisal, where I'm actually suggesting that what are considered infringements of equal rights are really best understood as limitations on powers. So rather than saying, for instance, that the state of X, New Hampshire, violates the rights of gays and lesbians in limiting marriage just to opposite-sex couples, we really should conceptualize that if it does violate equal protection as the state of New Hampshire doesn't have the power to limit marriage in that way. So I actually take a different view that actually they're not separate, but rather one and the same.
Interesting.
Considering we've had about at least 31 shots at including the words right to privacy into the Constitution, and we have not done so over the past 220 years, is it more an argument for the state to have greater power and the government wants the states to regulate more closely to the electorate what privacy actually is within the state, or conversely, there really is no inherent right to privacy on a federal level?
Well, I think that's a very good question. It's one of these things where we feel like we have, and I say we very broadly, we have this right to privacy, and it's not anywhere listed, and so we extract it from different parts of the text because we want it so badly. But then when we actually start talking to lots of different people, what it means to have the right is different for lots of different people, because that countervailing interest that I was talking about is stronger or weaker depending on which community you live in. So I think it's probably actually right that we don't have a right to privacy broadly conceived, and that's the way law works. We have little iterations of freedoms, not rights. So it's not an affirmative right. It's not the right to have something, but it's a right to be free from certain kinds of intrusions, and what those intrusions are developing over time.
At least with respect to tort law, which is where the states have traditionally had preeminence, You know, in New Hampshire, there is a cause of action for a violation of your right to privacy. I couldn't give you the elements of it because I think we saw one case in the last 12 years. But that's an area where the states have some authority that the federal government, unless it passes a statute, doesn't really play a role.
That's excellent. Most states have privacy laws of some kind, and they have different elements. They vary state to state.
I have a question related to that in regard to spatial privacy. Why is it that we have an expectation for privacy at all when it comes to spatial privacy? I was wondering if anyone on the panel had a story that they could share. It seems very clear bodily autonomy and information privacy, the reasons why we have that, but hearing the cases where it's the police versus the drug dealers, it doesn't seem clear to me the reason why there's spatial privacy.
Well, I think a lot of it is historical, to be perfectly honest. I mean, a lot of law grows out of property law, English common law and English property law, where they had property was considered a very important value to be protected. And so that if you invaded someone's privacy or property, it was protected, and there was an action against the government or against other people for doing that. In fact, there was a line of cases up to the end of the 19th century in the United States Supreme Court where they took a person's private papers were considered sort of part of yourself. And so the government couldn't get your private papers because that's the way people kept their thought processes, by writing diaries and those kinds of things. And so the government was not allowed to get to that kind of stuff. I mean, that's not the law anymore. If you have a diary now, it's subject to the same pretty much limitations as any other document. So I think historically the notion of the sanctity of property has developed so that it's really enshrined in a very strong way, as Professor Silvy's, in the Constitution and in the cases. It's a line that's really a very firm line, and I would say it's historical more than anything else.
But the judge did mention we have privacy in our persons. That's what you said, and that's absolutely true. It doesn't say homes, and so I do think it's a historical vestige. I think it's very strong. I think it's one of these examples of line drawing. Judges need to draw lines, and legislators need to draw lines all the time that are hard lines to draw. The home is an easy one to draw for people. It is an easy place to say that is where you are safe and private. It's why we have certain rights around guns relating to our home, not relating into public, for example. It's just a very clear line. Whether it's a meaningful line anymore is what you're asking, and I would agree that it's being pushed to the limit.
I would just add one other thing. When you look at all these criminal cases, one of the audiences out there is law enforcement. And law enforcement needs pretty clear guidance as to what they can and can't do.
Right.
And that's the problem with the Jones case, in my view, is it doesn't provide a lot of clear guidance as to what law enforcement can do in the future. I mean, there are literally hundreds and hundreds of criminal cases every day in this country, and it can't really function if we have a lot of mushy principles that judges like me have to apply on sort of an ad hoc basis, because we're bound to get it wrong.
We have time for one more. Sir.
Given the line of cases that came out of the right to remain silent, all of that, should there be, in that Baker versus Carr says that the Fourth and Fifth Amendments are the pillars upon which the Bill of Rights is based, should there be a Fourth Amendment warrantless search, right? In other words, a Fifth Amendment warning for the Fourth Amendment for a warrantless search right? You teach warrantless searches and then teach the exception to warrantless searches for 6 weeks. What's left of those?
So you're sort of a Miranda warning for searches?
Correct.
Right.
Warrantless search.
I think it's a great idea. The problem is the United States Supreme Court explicitly rejected it about 40 years ago in a case called Schneckloff versus Bustamante and some other cases. So it's not something that's required by the Constitution, but I'll tell you that as a matter of practice, lots of law enforcement agencies do that because they want to make sure they have a valid consent. So they'll advise people of their right to refuse to consent, and they'll have them sign a form. In New Hampshire, a lot of law enforcement agencies do that.
Just a Supreme Court case that came down, the murder for hire case, just 3 days ago. And no, it wasn't the Brooks case. It was the woman who hired the boyfriend to, and her son and another to come into the house. Explicitly in there.
Right.
She signed
She
a
agreed.
waiver.
Right,
She
she
agreed,
agreed.
and they gave her a waiver and
Right.
to consent to search, and that was the best evidence they had that the search.
Right, so the law enforcement goes beyond very often what the Constitution is required, but that's sort of, a lot of them just err on the side of protecting themselves because they oftentimes, most of the time, have plenty of reason to do the search or to do the interrogation, that they need to cover themselves because they know it's going to get litigated.